Today we are going to speak about the Pugdi system in India and very specifically in Mumbai. The Pugdi system, which is usually a tenancy created for a longer period, this is the subject today which we are going to talk, whether it is legal or not. I'm Sanjay Chaturvedi. The program is brought to you by the Saptakala Real Estate Law Journal in the Indian Real Estate Study Forum, study which we are going to enhance each other's knowledge. And you can always write questions, email to us, or put it in the box below that what exactly subject which you think, and if you are interested in some subject, then we can always take some subject later on in this forum. Now, coming back to our subject today, the Pagri system is basically a longer lease which is started in 1949 and in Mumbai, and it was illegal till very recently. We are going to talk about the legality aspect, the illegality aspect of it, and why it was illegal and why it is now legal, and what are those taxations and how you can transfer tenancy, whether you can surrender tenancy, whether it is will, or whether it can be succession, or whether it has inheritance substance into it. So various aspects of the Pagri system which we are going to speak today, and understand that what is the current scenario as far as the Pagri system is concerned. Very popular in Maharashtra and very particularly in Mumbai. Now, the it is of the interest to know the government of Maharashtra came to change its policy on this issue very later on. That means somewhere around in 1998 actually, and then it propagated into a act which we look at into the illegal status of the Pagri system before the Maharashtra Rent Control Act 1999 came into effect, and we'll see that how it evolved into the legal practice that is in the prevalent today, or it is in practice today. Now, Pugdi system, if I take you back in, say, before the Maharashtra Rent Control Act of 1999, the practice of the Pugdi system is as old as the tenancy system, I tell you. The premium or the Pugdi we call a deposit, or as it is known widely as the payment of the money on the grant or surrender of tenancy, either by the tenant or the landlord, is basically actually in old days since 1949 onwards, since there was a lot of black money involved into the real estate transactions, and usually it is said that the a lump sum amount is being paid to acquire the property, and a nominal rent is being kept just to show that it is a longer lease. Or this is a theory which various people may not agree with this, but that was the era where the a lump sum amount was paid to the landlord in lieu of the tenancy creation. Now it is a consideration or paid either by a tenant to a landlord for grant of the tenancy, or by a landlord or a subtenant, as the case may be, to the tenant for the surrender of tenancy right. The Transfer of Property Act 1882, while defining lease in section 105, states that a lease can be created or granted in consideration of a price paid or promised, or for any money apart from the consideration or periodical rent. In lieu of that, money which is being paid. The consideration mentioned over here is basically is nothing but a pagri. Pagri is a deposit, or you can say a lump sum purchase consideration at the time of taking up possession of a particular property, which is a lump sum amount. Now, as held in the Commissioner of Income Tax, one very landmark judgment on this is as held in the Commissioner of Income Tax versus Panbari Tea Company, AIR 1965, Supreme Court 1871. The premium is really the price of the right to occupy for a period, while rent is returned at some percentage on such price during the period and of the lease by the periodical installments. This is the landmark judgment which was there in the, and that was how the pagri was actually defined in the in 1965 by the Supreme Court. Now, according to the Transfer of Property Act, the Pugdi system is a statutory legal, unlike in the Bombay Rent Act 1947. That time the rent was frozen actually, and in somewhere around 1998, if I'm not mistaken, that there was a scheme came that you pay 100 months rent and take the ownership of the property, and that was also challenged in the Supreme Court, and then the scheme got disaffiliated, and it was not gone into very well into the landlord and tenant. Now, according to previous rent laws applicable in Bombay, we call it prior to Mumbai, it was Bombay. The Bombay Rent Act 1947, any consideration received by a landlord, maybe a property owner, or any person acting under the landlord, maybe ostensible owner, maybe a trust is there, whether trust is taking or partnership firm or any director or any ostensible owner, maybe a guardian for a minor. The other than the standard rent or permitted, which is increased for consenting to transfer the tenancy, maybe a premium which we usually take it, or creating sub tenancy or to or any other tenancy was unlawful, and the landlord on conviction can be punished or with imprisonment for a term that may extend to up to 6 months also, and with the fine not less than the amount of the premium which he has collected, this according to the section 18 of the act. Now also, any consideration received by the tenant or any person acting under him for relinquishing the tenancy right is unlawful and may be punished with the imprisonment. That was the prior to 1999. Now, basically, it was a social evil where people have actually taken. Landlords never say that we have received the money, and the tenants always say that we have already paid the entire consideration of the that time, because the transaction was not legal. That's why they could not put it in a ownership format, and still the Pugdi system is continuing even after when it is a legal in a legalized form. Now I tell you when the Pugdi system got legalized. We can say that there was one joint committee after in there was a national housing policy was uh, promulgated at in somewhere around 1992 to 1998, and in between the national housing policy came up with saying that we should have actually rationalized the rent control and have a common rent control into the this. So the policymaker thought that why to not have a Pagri system legalized, and there was one joint committee unanimously decided that one joint committee was actually formulated by the government of Maharashtra, and they have unanimously decided to consider the legalization of the Pagri system, and it would have actually many advantage. The first advantage legalizing a system will be that it is curbing the black marketing, which otherwise could not be kept in check. And secondly, the public's amount would be bought under the purview of the taxation. So even the surrender of tenancy right, or you are creating a longer lease, then it can be stamp duty and registration is required for more than 30 years of the lease period. Now, the Maharashtra Rent Control Act 1999 and the Pugdi system. That is how the Maharashtra Rent Control Act brought the legalized format for the Pugdi system is that under Section 56 of the Maharashtra Rent Control Act in 1999, they have thought of various aspects of the Pugdi system. And the first is that the tenant or any person acting or purporting to act on behalf of the tenant, or to claim or to receive any sum or any consideration as a condition of the relinquishment of the rights of the tenancy, or transferring or assignment of any tenancy of his premises. And secondly, if the landlord or any other person acting or purporting on as a behalf of the landlord and to receive any premium or maybe a deposit or any lump sum consideration or whatever in respect of the grant or renewal of the lease or any premises for giving his consent to the transfer of lease. Now such type of is treated as a lawful activity in the act. A corresponding provision has been made in section 55 of the act, which makes it compulsory for both the parties to register the lease, the landlord and the tenant to make an agreement and in writing and get it registered. See, as a result of this compulsory registration, or the parties will have to pay the stamp duty registration charges and make the document a legally valid document. Otherwise, anything which is not actually registered or stamp duty paid is void ab initio, because it is now compulsory for every lease which is being created under the act need to be registered. Now, since when it is need to be registered, all the tenancy, all the lease deed has to be lawfully acknowledged by the act. The object behind legalizing the Pugdi system was to keep the check on the problems, and there were very misconceptions in the Pugdi system. And basically, we know that we need to pay 33% to the landlord at the time of transferring the tenancy or selling your tenancy right to some other person. It is because there is nothing written as such in the act or any law, but 33% is basically a premium or NOC charges which the landlord usually take. But this is the nomenclature which is not actually a force of law. It is basically a NOC which usually a landlord demands, because the title and the conveyance is with the landlord. And in the property or in real estate, whosoever has the title only can either give or lease or transfer. Mind you, lease is also not a sale basically. In RERA, if you, the moment you say it is lease, you are out of RERA ambit. So there is a difference between lease and the sale. Yes, more than 30 years lease now under Section 50C of Income Tax Act. Now it is being treated. You need to now register also, and every aspect of the lease now it is being treated, and it is subject to the capital gain taxes. Can I inherit the lease? Yes. Can I do my will to the lease? Yes. And the last question, which was the very interesting question, was how to terminate a Pugdi system or how to terminate a lease. There are five ways to terminate the lease or Pugdi system. That is, you change the use as a tenant, and the landlord got every right to then throw you out of your premises. you change the layout or the major change in the orientation of the property, then the landlord got every right to throw you out of the property. Landlord wants to have a self occupation, they can always all go to the court and ask the court to, as a tenant due, to vacate it because they want to have a self occupation of the property. Fourthly, creation of the sub-tenancy without the NOC of the landlord, then also you are vulnerable for throwing you out of the property. And suppose if you do not pay your rent in time, then also one of the condition is that the Pugdi system can be terminated. Hope you enjoy this. I believe there are a lot of questions on the Pugdi system. Pugdi system is now a legalized system. Previous to uh, 1999, it was all unlawful. Now it is legalized. Uh, if you have any questions, you can always put it in the checkbox, or you can email me on editor@saptakala.com. I'll be more than happy to assist you with more research on the subject Pugdi system. But it is, I tell you, it is a huge subject which only some few points which I have already told you. There are many aspects because it is now 60, 70-year old transaction process, or it is in practice. Now, very recently, that is just last 20 years, 20, 15 years, we have seen that the public system is getting legalized. Mostly the problem arises when there is a development or redevelopment of the property. And at that time, then even a tenant do not have a exclusive ownership, neither the landlord is having the entire ownership. They have to part their consideration, or come forward and jointly come and do the redevelopment, or take whatever the consideration they are supposed to get if the new entrant, the developer or the builder, is giving you. I'll be taking much more interesting subject in the coming weeks on this platform. Subscribe to us and be in touch. Till then, goodbye.